Thank you and welcome to the latest NACM Ethics Subcommittee discussion, the recorded portion of our committee conferences on various topics on ethics in court administration for court staff and court managers and court professionals. Thank you for joining. This afternoon, I'd propose we discuss inside information. We may not be stockbrokers, we're not day traders, but in our role as court employees and court staff, we learn a lot. We know about patterns of litigation against businesses, against neighborhoods, against professionals in the community. We know about protection order filings against real estate agents. We know about leaking basement litigation. We know about roofing contractor litigation. In our position as court employees, we learn a lot. Some of those cases are sealed, of course, and confidential, but most of them are wide open, available to the public if they were to search it out, often in almost every jurisdiction. But because of the nature of our jobs, we learn about it and know about it to a degree far more frequently than the public does. So I propose this afternoon we discuss, okay, what's the appropriate use of that information? What do we do with it? How do we apply it in our own lives? If our next door neighbor were to ask, who's a good roofing contractor? Do we get to mention the otherwise public history of litigation on ABC Roofing Company? And if ABC Roofing Company really does exist in any of the jurisdictions and ever watches this video, I'm just making you a hypothetical. Have any of us ever applied what we've known in our heads about litigation patterns or anything else at court to any transactions in our personal lives? In other words, do you drive past a certain auto repair place because you know the case history back at the office?
Not exactly that, but in a drug court, I mean, there were some attorneys that were part of the drug court or doctors or, teachers, and they were still working in the profession in some situations, or they were in the impaired, but also acting in a professional capacity. And it was kind of strange. It's a hard situation to be in, but we felt that they were protected for sure, and couldn't really disclose all of that, but it does make you feel uncomfortable.
Do you think it's appropriate, Kent, to, for particularly frontline staff to?
I think I would refrain, or at least attempt to refrain from answering questions related to specific businesses. If I knew that, or specific professionals, if I knew that there was something about them that might be compromising of the, I think I would probably say you should do your homework on that. You might want to check into that, but I'm not going to tell them specifics about, this thing that I know or not. So I think that's a way to at least put somebody on the alert without revealing too much. It still puts the onus on the consumer to do their homework.
Any thoughts, Eric? Some court staff might say, well, you can't compel me to have amnesia about what I encounter in my work life. I mean, I can't help but know certain things. Given that, I mean, is some application of what I'm calling inside information ethically okay?
It's a tough question. It really is a tough question to answer. I would probably not want to go there at all, but things come up all the time. I can give you one great example, and it's not exactly on point, is, all of us are in court and we certainly see attorneys, and we see how some attorneys are maybe a little more proficient than others. The reality is the word kind of gets out, and I don't know how you keep that from happening on a practical basis, but it is a really tricky situation.
Application of what we learn at the offices is ever appropriate for court employees. In other words, you drive past that car repair place because they've been sued 4 times at the office. If a friend asks you, well, who should roof my house? Who should remodel my kitchen? Is it ethically okay to offer some of that information on past case histories, for example? What do you think?
Past case histories is public information. So I would say, yeah, you can do it. I think I'd also refer people to Better Business Bureau.
I wonder, do any of that touches on, though, how we distribute and how we use otherwise public information? I mean, there's a lot of inside stuff that we know, for example, a judge's pending decision that we may be aware of before the decision is issued. So, but I think those are generally pretty rare. There are other situations, though, landlord-tenant protections, for example. I mentioned in the topic summary distributed to the members earlier today that some jurisdictions are cautious or have passed restrictions on landlords against using case histories, eviction case histories, to withdraw occupancy or rental contracts with certain tenants, putting the tenants at a significant disadvantage. Otherwise public, but we've imposed certain restrictions for social justice or appropriate social reasons. So because we work for the court, we get to use that information, but the landlords, for example, in those jurisdictions who have restricted the use, don't get to use the case histories?
And how do you enforce that anyway?
Good question. We don't have that here, but I wonder if any of the participants on the call may be in a jurisdiction where they've actually considered those restrictions.
Mhm. I can see if it's a blatantly public document that, or a document which is out on the internet that says blacklist of tenants or something like that. I mean, something really blatant. Okay, yeah. But it's usually not the kind of thing that they advertise that openly. It may be some kind of a listing, an Excel spreadsheet, which you pass around privately between property management corporations or things, isn't it?
That is the type of thing you hear about.
Yeah, you always hear about it at the water cooler or as a rumor or something, but you never really track it down. I mean, it's not for us to be tracking that down.
I get the impression that some jurisdictions have adopted restrictions like if property management firms hire a third-party data collector, can't then trade or sell those lists of eviction defendants to each other, that you can't make it a commercial activity. Although, I would imagine third parties harvest the court's data all the time. And I'm not sure how we'd necessarily assert restrictions downstream.
Yeah, you were the one who told me about that company that goes around and is trying to get a leg up on civil complaints that are filed in various jurisdictions around the country.
Yeah, access to the clerk's baskets.
Yeah, before anybody else has it.
Eric, you put your finger on something a little earlier, I think that might be worthwhile discussing a little further. And that's, we get asked, okay, who's a good attorney all the time? Because we work at the courthouse. We see them in action all the time. There may be a distinction there, though, I think, because, attorney competency, or whatever we want to call it, is to some degree anecdotal or subjective. Case histories, on the other hand, are pretty, as Peter mentioned, are pretty objective, pretty clear. I wonder if you think there's a distinction between those two then.
Well, I don't want to muddy the waters in my response, but I probably will. In a related concern, what we're going to have a real issue, I think, here in Arizona. I think in some states you put in various provisions for expungements, but yet the court staff would probably know the prior history. So one of the concerns we're going to have, I think, from a practical matter is, how are we going to keep our court staff from perhaps knowing this information and not necessarily sharing it, where for purposes of public inquiry and inquiry of employers and so forth, some of these convictions did not exist. In January, we're going to get a lot more files that will be sealed. So the complexity is really starting to get mind-boggling on how we use this information and what can and cannot be disclosed. But I guess I didn't answer your question, but
No, you did, and I think you get to an interesting area too, because we ran into I got an angry call from a member of the public last week whose case had been sealed or expunged under the provisions in state statute, but that data had been harvested prior to the expungement. And now it's available with a third-party data collector. And so it doesn't matter how tightly the court seals it or how cautious we are about using what we know, to sort of get back to the topic overall, it's all, regardless of our efforts, it's already out there.
Mhm.
and some of what's out there isn't even accurate.
Right. I wonder, because I haven't paid attention to the issue very closely in recent months, if there are still a lot of legal contests on risk assessment formulas and all the AI applications and how likely it is for this defendant to appear at his next court date. As I recall, there was some significant litigation in that area, but I don't know what the evolution has been lately.
Yeah, I mean, if we're gonna go down that rabbit hole, I mean, I think that one of the primary considerations there is that there's not enough data going into some of those, AI development to know that they have a good algorithm on which to base their decision making. Is it sufficiently diverse in terms of the groups? Is it sufficiently large? What are the biases that may go into it, and how transparent is the code? Blah blah blah, and that's where you get a lot of debate.
Dawn, you've been pretty quiet. Any thoughts on any of the angles in this topic?
Coming from the juvenile world, I mean, a lot's confidential, but bail has been interesting, and we do a risk assessment, and a child scores high enough to get out of detention or not, but it just takes one bad case where it's a major crime and they become an adult, they're going to the adult system, and then everybody's got information on the case, and they should have remained in detention and should have remained, in the system, but you don't have all the facts. And I can't tell you all the facts. So
Mhm.
it's hard, to
Have
be
there
able
been-
to explain how the system worked.
Have there been challenges to your risk assessments? I mean, legally or just, agency to agency sort of thing?
No, because usually they become part of the adult system
Hmm.
at the next level,
Mhm.
because they're charging them as an adult, even with raise the age, it just seems to work that way. The biggest issue right now is when they go into state's custody, the state hasn't had all of the placements that they were supposed to have because of the budget cuts. So juveniles are escaping, and they've committed major carjackings or murders and things like that. That's where it's more of the assessment of what level of care is coming into question.
Sort of on a related issue, I wonder too, that we started on this topic with, okay, how do we carefully and ethically handle the information we have and we know? When it comes to those risk assessments, that what's often sold as numeric objective data, have you also had requests for a lot of sharing? In other words, the school districts, for example, here are very eager to get their hands on a lot of that juvenile data because, understandably, if someone's charged with if a juvenile's charged with an aggravated assault in the courthouse, the school the next day sure wants to know.
Yep.
Mhm.
Have you had discussions around that as well?
We have, and we had issues in the past where the juvenile was, expelled as a result of some of the information. And we're trying to work together as a system. And the last thing we want is the juvenile to be out on the streets and not in an educational setting. So we've tried to work as a group, and that's what brought us to the children and youth planning boards and more key stakeholder approaches and things like that. And we sign an information sharing agreement, and we state exactly what you can use it for.
Yeah, in our experience, it gets really complex really fast because of course, the the juvenile's defense attorney, for example, is going to argue, well, that allegation you just shared with the school district is a complaint, is a charge that has
Right.
yet to be proven from the prosecutor's office. And so it's not yet been adjudicated, so it ought not to be shared. I mean, some really complex constitutional and data sharing issues arise pretty quickly.
Exactly. It's cost kids acceptance into special schools, the next level school, or scholarships, or, jobs. And we don't want that.
Any concluding or wrap-up thoughts that anyone has on how we carefully and ethically handle all the information that we encounter in the course of our jobs?
I was just thinking from a human resources perspective, and you were talking about the employee policies, that we want to be sure that we're not spreading misinformation, because not every staff member has all the facts. Stop the rumor mill around the courthouse, because many times you're giving information to a judge who's supposed to be impartial. It could be considered ex parte communication. And we just want to be professional. I mean, would you want somebody talking about your case is kind of how I pose it with someone else? No one wants to know your child support and how much you have to pay. Why would you go share that with someone else?
Any concluding thoughts on discretion or our public responsibilities and handling what we know?
I imagine there's a little bit of difference in terms of timing. At what point does something become part of the public record? Whether it's something you have to go into the court to get or can get online, either way. I mean, there's some things that may or may not be allowed at trial that may be in the record somewhere. Well, not in the record, but in the files. So those are things that obviously you have to be careful about mentioning. And we've covered that to some degree, but it wasn't so much on the angle of timing. At what point, you know what's public and what's not, and can be safely mentioned, which is similar to, insider trading in terms of having advanced knowledge of something before the general public would.
Maybe in this age of so much increased information that is accessible in terms of the NACM Code of Conduct, we have to turn back to ourselves and our own sense of professionalism, that maybe no one is going to counsel you or discipline you for sharing this information, but it lessens your ability of being a court professional. It lessens your standing as a court professional, and maybe it's relying more on yours and my personal feelings about professionalism in our careers that we must rely on, as opposed to fear of discipline for sharing information that's inappropriate.
Eric, not to put you on the spot, but any final thoughts before we hit the leave button?
Oh, I think we've pretty well covered it in many ways. There's a lot of levels to all this sort of information, and I think Peter really sort of hit it. I mean, we really should be, just impartial arbiters of disputes and supporting that effort. I think us sharing opinions regarding the outcomes of these disputes, it just diminishes us all.
Well, thank you all. We started with whether my knowledge of case filing patterns should lead me to pick a different roofing company when I need to reshingle my house. But it's far broader and more complex, and as technology advances and data applications advances, gets even more challenging and more complex. Yeah. Thank you all for your time this afternoon, and I think we're concluded then. And Courtney mentioned that we've got no meeting in November, December, so I assume we'll see each other in January.
Thanks for joining us today. A Question of Ethics Conversation is a regular segment on ethics, courts, and court administration. Today's episode will be available on our website, in the Court Manager Journal, on the Court Leader website, on YouTube, Facebook, iTunes, LinkedIn, and on Twitter. Become part of the conversation. If you have questions, comments, or ideas for future episodes, email us. Our address is ethics@nacomnet.org. Did you hear an interesting comment by one of the panelists that you'd like to listen to again, but you don't want to search the entire episode to find it? The additional resources section on the web page contains a question time marker sheet. Just find the discussion question on the sheet, and next to it was the time that question was asked. You can then quickly fast forward to that time on the episode and listen to the panelists' comments. Remember, if you don't have time to watch an episode, you can always listen to the audio version. Listen in your car or on the bus on your way to or from work. You never have to miss an episode. I'm Pete Kiefer, and on behalf of our guests, the Court Leader website, and the National Association for Court Management, thank you, and have a great day. The views, information, and opinions expressed during this episode are solely those of the host and the individual presenters. They do not necessarily represent the position of the National Association for Court Management.